All right. Good evening. Um, Here a little bit later than I had planned, but I'm here for an irregularly scheduled Delete Lawz lawsuit stream. So since I last streamed about this, he's made a couple of dumb filings, as you might expect. And he's hello, Lois. So he's done a few videos that are really, really dumb. William Graber, good to see you. As you may know, my policy is I don't play his videos, not because I'm scared of his false copyright strikes, but I hate his voice. I hate listening to him. I watch other people cover him. That's how I see his videos. So the first video that I want to discuss. Now, I know Delete Lawz hate watches people who cover him. I don't know that he's discovered me or not yet, but this first part of the discussion is aimed directly at Delete Lawz. So I'm going to do it right from the start so that if he does find this to hate watch, he can at least listen to this. Don't threaten judges. Don't threaten judges. That being said, so if you don't know what I'm talking about, it's been covered by a lot of other YouTubers. Dog Detective covered it nicely. The Not the Brightest channel has shorter edited streams. That's where I first saw it. Oleg Welch. So if you haven't seen the videos, go watch it from one of them. Merb, the California lawyer, has also discussed it. And to an extent, I agree with Merb. Delete Lawz is being really dumb, but he hasn't crossed the line into doing anything illegal yet. But the line between being on the right side of the law and having U.S. Marshals show up at your door is very, very, very thin. It most certainly was you this time. But so basically, I'm going to tell a story, a true story. Between my first and second year of law school, my internship was with the U.S. Attorney's Office here in Salt Lake. The week before I started, the new federal courthouse here in Salt Lake opened up. It looks like the Borg cube. It's awful. But it was needed. The old courthouse, which is now the bankruptcy courthouse, is beautiful, absolutely gorgeous, but it needs a lot of work and it's way too small. And post 9/11, courthouse security has ramped up. So the the new courthouse is a good 20 or 30 feet above street level, the entrance, and steep stairs with bollards, so you can't drive up and into the building, and no Oklahoma City style bombings. But security inside the courthouse wasn't considered by the architects to the extent that it should have been. For example, in a standard courthouse, the prosecution sits on the left and the defense is on the right. The problem is, in this courthouse, the defendants enter, depending on which courtroom it is, either from the left or the right, and so they've got to drag them behind the prosecution table on some sides, and that's a security risk. So, very first day the courthouse opened, maybe day 2, I think it was day 1, first hearing. It was an evidentiary hearing where it was Tongan Crips gang. So the defendant was already a prisoner. He was sitting at the defense counsel table, and another Tongan Crip member who was also in custody was testifying at the witness stand. The defendant didn't like that. And as I said, Tongan Crip, he's built like a linebacker. Well, was. He had his wrists shackled, but his ankles were not. He stood up, grabbed a pen, and ran at the witness, diving over the witness stand to start stabbing with a ballpoint pen. The marshals shot and killed him. So, and then I started my internship days later. So, one of my very first days in the internship, they had an office-wide meeting, all the assistant U.S. attorneys, all the paralegals, legal assistants, everyone. And they discussed personal security. And what they discussed was, this is how you force the White Pages phone book to remove your contact details. This is how you get all of these websites to remove you. This is how you stay hidden on any social media that you are using. And by the way, don't use social media. So they were using the force of the federal government to force web pages and the phone book and everything to delist them. And yeah, these are prosecutors, but I guarantee federal judges have the same training. They have the same resources. They have U.S. Marshals and the court security officers telling them, this is how you stay safe. This is how you stay hidden, because federal judges make enemies. So what I've seen so far from Delete Lawz, he hasn't crossed any lines. But if Judge Burroughs isn't listed, her address isn't listed, if her family members are anonymous, if he releases this, he could find himself in major trouble. Major trouble. So he's not there yet. He could find himself there very easily. And as we've seen, he's dumb. He's easy to troll. And he put out a call. If anyone knows any information about Judge Burroughs, send it my way. He's going to find himself trolled into criminal charges. So, but even beyond that, once again, this is directed straight at Delete Lawz. Judge Burroughs does not care about you. She does not care about your politics. She doesn't know your politics. She's not watching your videos. Although if she is watching your videos, which she's not, it's your fault because you put them as exhibits in your filings. So if she's watching them, it's because she's decided, hey, it's an exhibit, it's relevant, but she's not watching it. If she thinks they need to be watched, she's making her first year law school intern watch it. She doesn't care. And you, Delete Lawz, are just one of 1,000 assholes she's dealing with at the moment. You're not the most interesting. You're just not. I mean, you've read her record. She deals with mobsters. She deals with drug traffickers. She deals with very bad people. She deals with very high-level decisions that have national implications, even international implications. Your petty squabbles are not interesting to her. She forgets you exist when she's not looking at your drivel. She forgets you exist. But then every morning when she opens her email and sees that you filed another document, she says, oh, not this asshole again. But she says the same thing about Josh and Kate. You don't matter. She's not biased. She's giving you an exceedingly fair trial. I mean, we've seen, and even in the first document I'm going to go over, you're still trying to weaponize your pro se status. She is going easy on you. She just is. But once again, she doesn't have to accept your facts. She's a judge. She gets to decide whether your facts are credible or not. She doesn't find you credible. But besides that, you're getting basic procedure wrong. And we've discussed it already in previous videos. If I do decide to read the Ironton filings later, we'll see, because this is going to be a long stream. It's even in those. You liberally construe pleadings, as in, if there's some, you can get a motion out of it, you do. But you don't get help on civil procedure. You have to follow those rules like an attorney. You're not. So moving on, video number 2 that I want to discuss. And this is his lawyers are scum videos, never get a lawyer, and never take a plea deal. Every word he said in that is baloney. He he made claims that you show up to your pretrial hearing or arraignment, although really he was discussing an initial appearance, but and you get surrounded by attorneys yelling and screaming at you, take a deal, take a deal, take a deal. That doesn't happen. Here is what I've done. Now, not every attorney does this, but here's how I do things. So I show up at the courthouse. Generally, for arraignments, initial appearances, the sort of the morning calendar, the prosecutor might not be in the courtroom, because right outside the courtroom, there's going to be little conference rooms, breakout rooms. And the prosecutor is going to be holed up in that, meeting with every defendant or their attorney. And so I'll go in and I'll meet with my client first, and I'll have them sit out in the hall while I go in to meet with the prosecutor. And there are a couple of reasons why I don't want my client in there. Number one, I don't want him saying anything to the prosecutor. And if he's not in the room, he's not going to say anything. Simple as that. But also, sometimes I've got to really fight for a plea deal. Sometimes the prosecutor gives a good plea deal right off the bat. I don't want my client to see if it was easy or hard, because I don't want them questioning, well, why am I paying you? But that's beside the point. So then what happens is I go out and I talk to my client. And I should say, I never accept a deal until I have discovery, until I've read the police reports, until I've seen the body camera. Because I don't know if I have a defense or not until then. So, but once I have discovery, I can go to my client and I say, hey, look, they can convict you on this. Or I go to my client and say, hey, look, the prosecution has a terrible case. Let's fight it. So, but at the end of the day, it's my client's decision. It's their life on the line. And Delete Lawz said, you know, they're going to hand you a pre-printed deal sheet, plea offer. I've never once had a pre-printed plea offer. They have it handwritten in their notes, and we'll argue back and forth. And then they have a form sheet that's different at most courthouses. And I will handwrite the agreement, and then I sign it, my client signs it, and the prosecutor signs it. And then we go into the courtroom. The prosecution never even comes in. And thanks for stopping by. So, and then we entered the plea deal. No yelling and screaming involved. I've never yelled at a client. I've been yelled at a client. I've felt unsafe around a client, like to the point where meeting with him in the conference room, I had a fellow attorney who was in the National Guard at the time and much bigger than me sitting in the room with me. because I didn't feel safe. I've never yelled at a client. The closest I ever came, I got this client an amazing deal. He accepted the deal. He was instructed to report to pretrial services, basically, for a pre-sentence investigation, and he didn't. And I couldn't get a hold of him, and that finally a warrant goes out, and da-da-da. His wife calls like a month later, and she says, he can't go to pretrial services. A water heater fell on his foot, so he can't leave the house. That's the closest I ever came to yelling at a client. And the reason is, most attorneys might have sympathy, but I'm like, do you think my leg grows back every time I go out for court? I've done every one of his court hearings with one leg. I know crutches are easy to use. I know wheelchairs exist. I know you could have got there if you wanted to. I'm the least sympathetic person to that argument. But that's the closest I ever came to yelling at a client. But yeah, so moral of the story, if your lawyer says, hey, look, they have enough to convict you, a plea deal might be your best bet. If your attorney says, hey, look, they don't have enough to convict you, don't take a plea deal. And here's the thing. Prosecutors aren't dumb either. They don't like to lose. If at some point your game of chicken is going to end, and if they know they don't have enough to convict, they're going to drop it before trial. So terrible cases never make it to trial because they're dropped. Great cases don't make it to trial because the defense takes a plea deal. It's the questionable cases that go to trial, or it's the Darrell Brooks. It's the, yeah, I'm guilty of sin, but I've got nothing to lose by going to trial. So first document we're going to take a look at is one of his most recent. And the reason is it ties in with the first video we discussed. So this is his supplemental points and authorities for plaintiff's motion to dismiss Joshua Abrams' counterclaim for lack of subject matter jurisdiction, which is Federal Rule of Civil Procedure 12B1. Now, this is some great argument here. The entirety of his supplement here. Counterclaim is also not logically related, a part of the same case or controversy, and therefore requires an independent basis for jurisdiction. McCaffrey versus Rex Motor Transportation, Inc. First Circuit, 1982. So one of the benefits for me in not rushing out and breathlessly covering every filing the minute it's filed is I also don't have to do my own research some of the time because Merv does it for me. And I do research, don't get me wrong, but this one was easy enough. Just seeing him. This is a 1982 case out of the First Circuit. But it's bad law. There's a 2010 case that overrules this out of the First Circuit, saying, yeah, you don't need an independent basis for jurisdiction, for supplemental jurisdiction. So this whole argument is nonsense. Now, even ignoring that, he says this isn't part of the same case or controversy. Well, first off, both counterclaims, Josh and Kate's, they both are counterclaims to his first complaint before, when it was a defamation trial. Well, defamation lawsuit. But I'd make the same argument even here in the copyright lawsuit. He says it's not part of the same case or controversy. Well, the case or controversy arises out of Delete Lawz YouTube videos and Kate and Josh's YouTube videos. So it is the same case or controversy. And I realize I haven't said it. Merb did a video on it. The judge is probably counting his supplemental complaint as a second amended complaint, and therefore Kate and Josh are no longer defendants and only YouTube is, and YouTube's going to yeet that case so fast that heads will spin. Well, until Kate and Josh are officially out, as in the judge says, yeah, you guys are gone, I'm counting them as defendants. Especially since once he realizes he messed up, the judge might give him a chance to amend. But here's the fun part of this. Request for a hearing. This is going to get him closer to trouble. Pursuant to Local Rule 7.1 sub D, I hereby request oral argument at the court's election on the issues presented in this motion. In ECF number 52, this court said, the court will not now transfer the case because plaintiff has had a change of heart, as appealing as that option might be. Boy, he's salty about that. In that order, and since then, this court has made assumptions and used harsh words towards me because of those negative assumptions, which certainly isn't just. Okay. When you toss word salad at the court is going to make assumptions of what that word salad means. When you change what you're asking for day by day, the court can only assume what you're asking for. And courts are snarky. Courts don't hold your hand and say, oh, there, everything's going to be okay. If you're being an asshole, the court's going to be an asshole right back. And besides which, the court won't transfer this case, as appealing as that option might be. That might be appealing just because the court has an overloaded docket and getting rid of a case lightens her workload. I mean, it's as simple as that. I mean, everyone needs to recognize his superior intellect, William Graeber. And that's actually, you reminded me. So either he's bipolar, well, I'm going to say tripolar, or there are at least 3 different people writing his motions, because you can tell, like, this one was definitely written by Delete Lawz, because it's just stream of conscious vomit word salad that doesn't mean anything. And it doesn't tell a story. It doesn't lay out facts and law. It's his feelings and nonsense. There are some filings that are a little better written. And then there's one that, although that might be the copied motion he mentions, that might be why it's better cited, but we'll get to that. So, I am a pro se litigant. We know. The court knows. A goosebump. But once again, he's trying to weaponize his pro se status. This is the first time I'm doing this. Bullshit. I mean, if Josh and Kate respond to this, they're going to have a footnote to this point saying, this is his lawsuit he filed in Ironton, Ohio. This is his failed restraining order against Kate in Woburn Court. This is his failed restraining order against Kate in this other court. This is him helping get Deborah Rogers thirsted in the Tahlequah jail. This is him engaged in the unauthorized practice of law
helping Eunice Lofty. This is him engaged in the unauthorized practice of law for the no longer pregnant chick. That, they're going to go back with his record and say, this isn't his first lawsuit. Look at all of this. I should not be attacked for simply filing a motion. You haven't been. It took 5 times for her to say, stop. And yes, your letter counts as a motion. You asked the court to do something. That's a motion, no matter how you title it. I'm not only in bold caps, it's never a good idea to shout at the court, even in writing. I'm not only being attacked online. Where are you being attacked? Am I attacking you? No, I'm criticizing you. I'm talking about you. That's not an attack. But now I feel I'm being attacked by the judge and the clerk as well. No, requiring you to follow the rules, follow procedure is not an attack. I mean, the clerk fixing your filings to comply with the court rules is not an attack. When I say that all of the witnesses for the case are in Los Angeles, and I didn't know that I could have filed suit in Los Angeles, that is not simply a change of heart. Yes, it is. Yes, it is. First off, the witnesses aren't in Los Angeles. Kate and Josh are witnesses. They're in Massachusetts. Besides which, you couldn't have filed in Los Angeles. Los Angeles, the Central District of California, does not have jurisdiction over Kate and Josh. The district court in Boston does. That is what transfer motions were designed for. Where's the law on that? Where's the legislative history on that? That's a Delete Lawz special conclusory statement. And a transfer motion is designed for when you sue Kate and Josh in Los Angeles and they say, no, this needs to be yeeted to Boston. Or it's just asinine. This court also seems to admit that I didn't make 5 motions asking for the same thing, but said it anyway, just to be hyperbolic, or is choosing to interpret filings in the most prejudicial way toward me instead of the way that I most reasonably intended. No. The court did not admit that you didn't make 5 motions because you made 6 motions. The court said you filed a letter on the record asking me to do this. That's a motion. And that's it, William Graber. How many videos are there where he gets in a cop's face at a traffic stop and berates them? You better do everything right because I sue people. That's what I do. But this is his first lawsuit. And interpreting his filings in the most prejudicial way, instead of what he most reasonably intended, be clear. Don't leave room for interpretation. But if she doesn't believe you, that doesn't make it prejudicial. Well, at least not unlawfully prejudicial. It just means she doesn't believe you. And when I ask for a hearing, in case you have questions that need answering, I'm not admitting to missing any argument that should grant that motion. He's not even passive aggressive. He's aggressive. He's condescending. Federal judges don't like being condescended. But when she denies a motion without a hearing, without even a response, it's because she doesn't have questions. It's because either she can't grant what you're asking for, or she doesn't believe you, so she's not inclined to grant what you're asking for. If you want what you're asking for, write better motions that are grounded in facts and law. I'm saying this court seems to be very curious about my intent when I'm making motions, and instead of filling in those gaps, please schedule a hearing so that I can answer those questions for you. How about don't leave gaps? Don't leave gaps. I can't go on a fishing expedition trying to guess at all this court's curiosities and trying to answer them every time I file a motion. So don't leave room for questions. First off, get all the case law in the first motion. Get everything in the first motion so you don't have to repetitively ask for the same thing. But don't leave room, don't leave gaps, don't leave room for questions. And find out what the standard is for getting what you want and tailor your motion to that standard. The trolls claim
It is impossible for me to get a fair trial in this court. It's beginning to look that way to me as well. What trolls? What trolls have said that? Are there trolls? I mean, this is another conclusory sentence. Are there trolls? The judge doesn't know there's trolls. Are they like? Did he file this in Mordor? And having the judge rule against you, that doesn't mean you're not getting a fair trial. That it means you're asking for things that the judge can't grant, or you're not asking. You're not giving her a reason to grant it. But here's the thing: the judge also denies Josh and Kate's motions. You're not special. And then there's his certificate of service, which is only funny to me because since John Doe defendants' identities are unknown, I was unable to send a copy of the foregoing documents to defendant or defendant's counsel. I mean, he's dumb. So, moving back in time, because I started with the second most recent motion, I think. This is another motion to correct the record, nunc pro tunc. Remember, nunc pro tunc means now for then. He still doesn't understand what that's for. He thinks, well, I meant to do it at that time, so therefore I did it at the time. But it's really more for the court had fat fingers and put an extra zero. So let's go back in time and remove that extra zero from the order. But plaintiff, and this is, he says, second motion. This is the 6th time he's filed it. Plaintiff, Jose DeCastro, plaintiff, or I. Never I. It's never first person. Never first person in legal writing. Hereby moves this honorable court to correct its record under Federal Rule of Civil Procedure 60 sub A and correct its record of my motion to correct. That's so awkward to read. Correct its record under FRCP 60A and correct its record of my motion to correct the recording of my notice of voluntary dismissal, which is true and in the interest of justice. In support of this motion, I hereby incorporate the attached memorandum in support. And this is why he thinks the court clerk is after him, because he filed this wrong. And so she separated the motion from, the memorandum from the motion and filed them separately. So the plaintiff's motion for a certificate of appealability. Wait. Did I screwed up. Hang on.
Yeah, I screwed up. That one hasn't been separated. It's the next one where he starts. So, plaintiff's memorandum in support of motion to correct record nunc-pro-tunc. The court has said in ECF number 74, plaintiff has moved for the fifth time. See ECF numbers 55, 58, 59, 66, and 73 for the court to retroactively find that his notice of voluntary dismissal, the notice, was filed before defendants answered his complaint. This court needs to correct the record. No, it doesn't. No. The record is the record. ECF number 55 is entered as a letter/request, non-motion. But you're asking the court to do something. That's a motion. And that was not an error when I specified that. So it's an attempted ex parte request. It's a motion. No matter how you title it, it's a motion. But maybe it needs to be corrected or clarified for this court. It doesn't. This document was a letter to the court, letting it know what occurred and where the best evidence was. But you were still asking it to do something. You were letting them know of their error, supposed error, and asking them to fix it. That's a motion. I was hoping that the court would, on its own, as it is able to under Rule 60A, correct the record if it had information of a correction that was needed. It's not. It's not. The order at ECF 57 does not specify that ECF number 55 was a motion. It doesn't have to. It was treated as a motion. Additionally, the order made a lot of assumptions prejudicial to me. Don't leave room for assumptions. And the court not believing you isn't undue prejudice. ECF number 58 was filed in error. I emailed the clerk about this, and she let me know that she corrected the record to make that clear. Perhaps this needs to be clearer. That is not a motion on record with this action. Well, then why did you file it, dummy? I mean, his voluntary notice of dismissal was accidentally not filed. ECF number 58 was accidentally filed. Get a lawyer then if you can't file things properly. Oh, wait, no, then this would cost you actual money. ECF number 59, although it says second, I don't know how that happened. You wrote second, that's how. It was my first motion. It was the correction from the mistake that happened at ECF number 58. Perhaps this does need to be corrected from saying second. This court found ECF number 59 moot due to my filing of an amended complaint without any relevant authority cited. It did cite authority. I mean, let's see, ECF 59. So ECF 65, the judge rules, plaintiff filed by right an amended complaint. which permits a party to amend its pleading once as a matter of course within 21 days after service of a responsive pleading. That's relevant case. Well, that's relevant law, relevant authority. In light of plaintiff's filing of an amended complaint, the court denies as moot his motion requesting the court to record his voluntary dismissal and notice as filed before the defendant's answers to his complaint. The court further advises plaintiff that because defendants have each filed a counterclaim, he must file an answer within 21 days. Blah, blah, blah. So here's the thing. He thinks the judge ruled that his motion was moot. That's not what the ruling was. It's that the issue is moot. The issue. So it doesn't mean, oh, well, the judge said my motion to nunc pro tunc go back and get my notice of voluntary dismissal recorded is moot. Therefore, because of the amended complaint, therefore I'll just file it again. No, it means the issue is moot. So no matter how many times you file it, it's the issue, not the motion, that is moot. And so in ECF 67, she does cite relevant authority, such as Intergen versus Grina. Yeah. So let's see. I'm still unable to find any authority that says that an amended complaint removes from jurisdiction any nunc pro tunc motions for correction from the court's jurisdiction. It's the issue that's moot, not the motion. You resubmitted to the court's jurisdiction by filing the amended complaint. ECF number 66 was a motion for reconsideration of the motion to correct. The court hates it when you ask for the same thing over and over and over. Unless something has changed, this is just repetitive and wasting time, and it's going to get sanctions at some point. I do understand that there is no official motion for reconsideration in federal court, and that this would be considered an amended motion. So ECF was a motion for reconsideration, but there is no official motion for reconsideration available. That is not an additional motion. It is. It's asking for the same thing again. But it is also proper for my exercising my due diligence at the error made by this court. Ooh, strong words there. Error made by the court. There was no error. There was no error. And this court found ECF number 66 moot. Due to my filing an amended complaint without any relevant authority cited. It has cited relevant authority. You, Delete Lawz, have not. It seems like this court was saying that I needed to bring the motion back into the court's jurisdiction by filing it again. No, the court said the issue is moot.
Well, I guess the court didn't specify that it was the issue that's moot, but a lawyer would have understood that. He did. Except on 58, where he accidentally hit the button. And while we're on about buttons, remember, hit, take a second and hit that button. Do all the YouTube-y things like subscribe, share, bribe your friends to do the same. ECF number 73 was logically my first and only motion to correct, since the others were found moot and not within this court's jurisdiction, according to its erroneous rulings. It's not erroneous. And the court didn't say it didn't have jurisdiction. It said the issue was moot. Additionally, this motion did, don't shout at the court, include additional arguments and cited authority for its arguments. Include those in your first motion, dummy. You don't get a second bite at the apple. This court has said that plaintiff has not pointed to any evidence that indicates that he actually filed his notice before defendants answered. True. Yet he says, this is incorrect. I said in my very first letter to this court that the court has the best evidence. The court doesn't have evidence. The court doesn't provide evidence. The court does not maintain the ECF system. The ECF system is hosted and maintained and developed by the administrative office of the federal judiciary. It's, I couldn't find this specifically, so I'm guessing, but I'm guessing it's in an office in Washington, D.C. The developers are in Washington, D.C. The servers might not be in Washington, D.C., but they're not in the federal courthouse in Boston. Why would each court maintain its own ECF system? It's a national system. The court does not have evidence. The court does not provide evidence. And once again, he cites an unpublished opinion. Board of Trustees of the Pipe Fitters Retirement Fund, Local 597 versus Commercial Cooling and Heating, Inc. From the Northern District of Illinois. So even if this were a published opinion, it's persuasive at best because it's a district court decision from Illinois. That's not in the First Circuit. I really wish, well, scratch that. One of the nice things about law school was the free access to the unlimited version of LexisNexis, Westlaw, and even the Bloomberg legal research tools. That's expensive, so I don't have it. I have the free legal research tools provided by the state bar, which is okay. I don't get these unpublished LexisNexis citations. But apparently this shows how the court could use this evidence. He also requested an evidentiary hearing under the same precedent. So I haven't been able to find this case. I don't know what it says. This court has said, first, although plaintiff claims to have filed the notice on November 6th, 2022, there is no evidence that he did so. In fact, plaintiff himself acknowledged in an email exchange with the clerk of court. He did. He said, oops, maybe I screwed up. I again refer you to the previous paragraph.
There is evidence, and my being polite and reasonable and admitting to other possibilities in an email to the clerk was not an admission of mistake on my part. It was an admission that there might have been a mistake. Besides which, the court doesn't have evidence. You haven't provided evidence. Your Google browser history is not evidence. It shows that you were on the ECF system. So published means it's precedential. It's used for precedence. Unpublished means you can look at it, you can see the citations in it, but it's not necessarily going to win an argument for you. And usually it'll have in bold at the top, unpublished, not precedent. And that's generally going to be at the district court level, although some appeals court decisions are. And I couldn't actually tell you why some are published and some aren't. I think it's basically like in this case, the pipe fitters case he cites. I'm guessing that the issue was so limited that it was tailored just to that case. And so they don't want it to even possibly be viewed as overruling cases they cited or extending cases they cited. So I'm not a judge. I don't. All my internships were federal agencies, not judicial internships. So I that's as far as I could explain it. So even if there was an error on my part, I again refer you to Waters versus Massachusetts DOT. Civil action. Once again, unpublished. This one's at least in the District of Massachusetts, which says that ECF system requirements aren't considered filing. So I can't remember if this is the case. Courts, well, ECF is filing. And if in a certain case they are requiring filing by ECF, that is how it's filed. The case he's trying to hang his hat on is a prisoner in custody handed his complaint or his writ of habeas corpus or whatever to the prison officials who failed to file it on time. He didn't have access to ECF. So handing it to the prison officials was his filing. Delete Lawz isn't a prisoner. He has access to ECF. Therefore, ECF is the only filing. I mean, once again, if they had taken his email saying, I'm dismissing the case, and they didn't file their answers the next day, he would have very next day, first thing in the morning, filed a motion for default judgment saying, haha, these suckers didn't file an answer, therefore I win. And they'd say, oh, well, you emailed us that you're dismissing. And he'd say, yeah, but an email isn't filing, suckers. It would be reasonable for this court to also admit to the possibility of errors with its ECF. It's not the court's ECF. It's the federal judiciary's ECF.
And you haven't provided any evidence that there was an error. And that's the problem. He is the dumbest person in the room who thinks he is the smartest person in the room. And so he plays his games, not realizing how transparent he is. People are smarter than him. It's easy to see that he's playing games. The judge sees it. The Josh Garrick sees it. Benjamin Wish sees it. I see it. Denying the evidentiary hearing that could easily prove my attempted filing per pipe fitters is a travesty of justice. No, it's not. You being required to pursue the lawsuit that you filed is a travesty of justice? No. Besides which, you're misapplying the law. You're misapplying the case law. Besides which, it's unpublished. It isn't even case law. But you're still reading it wrong. You're misapplying the facts. This court has said, moreover, the search history, which plaintiff refers to as metadata, that plaintiff has repeatedly submitted to suggest that he attempted to file his notice on November 6th, shows only that he visited the electronic filing website, not that he filed any papers with the court. That is also incorrect. No. That's what it shows. That's what it shows. That's exactly what I said the first time I read it. I mean, if you're going to include your browser history as evidence, include the whole URL. The title of the pages in the history is specific to when you're in the civil document submittal process. Additionally, I just now realized that the history that I printed does not show the URLs, but is also, as I keep saying, is not the best evidence. The court has the best evidence. The court doesn't have evidence. I mean, subpoena the ECF custodian or whatever for the ECF system. That's how you get that evidence. You don't say, oh, court, you need to show me how I won. That's not how it works. But yeah, the history is specific to when you're in the civil document submittal process. But the URLs, ECF's display menu, dispatch number. It doesn't have a document submitted URL. It doesn't. I mean, at least show the URLs from a successful filing. Show the URL for after you successfully filed. You can't, because it doesn't exist for that one. This seems best when combined with the court's evidence. Courts don't have evidence. Upon finding that I submitted this without the URLs showing, I will amend my first motion after previous moot motions to include the new evidence. It's not moot motions. It's a moot issue. Moot issue. This court said regarding the emails to opposing counsel that plaintiff contends support finding that he dismissed his case before defendants answered. I think you... Okay, this is all one sentence. This court said, and then in quote, ...
regarding the emails to opposing counsel that plaintiff contends support that he dismissed his case before defendants answered, ... end quote. I think you read the exhibit annotations incorrectly. That's one sentence. That's 3 fragments. That's so hard. And the court didn't read them incorrectly. The court read them the same way I read them, the same way Merb read them, the same way Dogtective read them, the same way everyone who's covered it has read them. The emails to opposing counsel were to address your argument of there is no evidence to suggest that plaintiff drafted the notice, or in ECF number 57. That's true. That there are bigger sentences, and we'll get to one of those later. At least I think it might have been on the first thing we read today. But just the choppy 3 fragments is hard to follow. But the emails to opposing counsel were to address your argument of there is no evidence to suggest that plaintiff drafted the notice. Whether he drafted the notice or not isn't the issue, though. It's whether he filed it, and he didn't. However, see in Houston versus Lack, a Supreme Court case from 1988, where notice was sufficient, absent filing for motions that require filing to become effective. What are the details in Houston versus Lack? Why was notice sufficient? This, Houston versus Lack, is the prisoner case. Houston versus Lack is the prisoner case. Notice was sufficient because he was suing the jail, the prison. He handed his motion or his complaint or whatever, writ of habeas corpus, to a prison official and said, file this, because they had access to file it. He didn't. That was the process. And therefore, they had notice because he handed it to them. You're not a federal prisoner. You're not a prisoner at all. In this lawsuit, the court has said, I'm requiring all parties to file by ECF. Therefore, all filing is ECF. If it's not filed by ECF, it's not filed. It's as simple as that. Additionally, it's clear that the defendants wouldn't be prejudiced by correcting this error since they had notice. No, they would be prejudiced. They would be prejudiced because they spent a lot of money filing their answers and their counterclaims. And they've spent a lot of money defending this lawsuit in general and allowing you to dismiss and then refile in Los Angeles, even though it'll be insta-yeeted. I never used yeet in real life, but as an Emily D. Baker fan, it is, motion to yeet is motion to dismiss. But it would be insta-yeeted if he filed in California because they wouldn't have jurisdiction. But it still costs money. So that would prejudice them. They also failed to complain to me that they didn't see the notice on the docket until after they had filed their answers. They don't have to. They could assume you changed your mind. They could assume that you're playing games. And they'd be right. I mean, They didn't complain, therefore it's not no. His logic isn't A plus B, therefore C. It's A plus B, therefore orange. They also seem to have a change of heart as to the dismissal of this action, as they had moved for its dismissal previously. Isn't this court in the habit of disallowing changes of heart? Their motion to dismiss at the very beginning of the case was denied. It was denied. They don't have to make another motion to dismiss. They don't. I mean, especially when well, first of all, he said, I want all of this stuff. I'm dismissing, but I want you to do all of this stuff, or I'm going to refile in California. So maybe they want to win on the merits. That's not a change of heart. This court said Local Rule 5.4a states that unless exempt or otherwise ordered by the court, all pleadings and other papers submitted to the court must be filed, signed, and verified by electronic means as provided herein. As I mentioned in Orders, local rules were hardly created to prevent justice and prevent Rule 41A actions that were filed, except for an error with the ECF. You haven't shown an error, first off. And no, the local rules were not created to... It's rare that people make me speechless. Additionally, Phoenix Global Ventures, the Second Circuit case, makes it clear that my declaration that I filed the document should be sufficient. No. Besides which, the judge decides if it's sufficient. Your declaration, the judge could say, I don't believe you, therefore it's insufficient. And that's it, Tad. If he files, it kind of depends. If he files and pays the filing fee, it won't be instituted. If he files in forma pauperis, asking the court to waive the filing fee, they'll review it first and they'll see, wait, we don't have jurisdiction, and then they'll say, all right, it's gone. But otherwise, they'll at least have to file a 12B1 motion, which costs money. So you are making findings against my credibility with no justification. She doesn't have to justify why she finds you uncredible. She thinks you're full of it. She doesn't have to believe you. It is defendant Peter that is known for forging court documents, not me. Ooh. First off, that's a declaratory statement. Where's your evidence? Where's your evidence that Kate forges court documents? And I haven't seen it. I mean, it's possible that she made a fake to troll someone, but that's not filing. That's completely different. That's trolling. But I still don't know exactly what's going on, but look at the Todd Lyons, the airline pilot that he's extorting into filing false affidavits. Look at all. I mean, how many affidavits did he file in his restraining orders, attempted restraining orders, where he provided someone a written statement and said, "Here, sign this"? He has no credibility. Defendants did not challenge my statements, only indicated they prefer that the case not be dismissed. That's all the court asked them to do. The court said the defendants are ordered to state whether they consent to the case being dismissed. It didn't say, right, why you consent or don't consent. And they said, we don't consent. That's all that was required. This court has no evidence that would defeat my declaration or evidence. But it doesn't believe your declaration or evidence. It doesn't have to take your declaration or evidence as true. The only things that the court has to take as true are 12b-6, motion to dismiss, or motion for summary judgment. And it's not that they're saying, yes, these are true. It's saying, assuming all of these facts are true, could we still come to a decision? You know, is there still no case? Or do you win on these facts and the opposition's facts? The court doesn't have to believe a word you say. She doesn't find you credible, and she doesn't have to explain why. Additionally, see in Houston, where notice was sufficient absent filing for motions that require filing to become effective. But your situation is completely different than Houston versus that. This court said that the clerk of court said plaintiff had not filed anything on the court's electronic filing in the month of November. First off, that's so passive aggressive. First off, I think it's obvious now that the document did not appear on the docket. Bingo. Bingo. This is an obvious statement and does not show there was not an error that led to that. But you haven't shown that there is an error. It's your job to show that there was an error. It's not the court's job to prove a negative. It's not Kate and Josh's job to prove a negative. The statement was also hearsay from an anonymous source that you filed as evidence. You submitted that hearsay. You submitted that hearsay. Kate and Josh didn't. The court didn't. You submitted that hearsay. Hearsay isn't always disallowed. The federal rules of evidence outline where hearsay is not allowed. It's not allowed in trial. In most motions, well, in lots of motions, I should say, it's allowed, even motions hearings. In front of a grand jury, hearsay is allowed. But besides which, he submitted the hearsay. So you yank that statement out because it's hearsay, and it means he's submitted no evidence at all. It's his hearsay. We do not know the extent of expertise of this person or what they even did other than look at the docket. You are the one who provided the statement to the court. The statement was not, plaintiff had not attempted to file anything on the court's ECF filing in the month of November, nor was it there were no errors in the ECF system, because the clerk of court would not have access to that. And that's it. Everyone else, whether it's his motion or their motion, it's their burden of proof. Never his. Never his. Conclusion. For the aforementioned reasons, I pray that this court will correct its motion of my correct its record of my motion to correct the record to reflect that it was only made once before being erroneously ruled moot, and then once to bring it back into the court's jurisdiction. The issue's moot. Done. Retain evidence. I respectfully request that this court take the steps necessary to protect its evidence. The court doesn't have evidence. In the form of digital records of the ECF system, the court doesn't maintain the ECF system. That shows all of my activity and not just successful activity free of error related to this incident on November 6th, 2022 and 7th. The court does not have that evidence. The court does not have the history of who clicks through what pages. It doesn't. The court does not have that information. I don't know that the actual ECF, the people who maintain the ECF, the centralized authority, I don't know that they have that. Besides which, if you want to get that, you have to subpoena them. Oh. Needless to say, that was denied. So, moving on. Document 82, filed December 7th. Plaintiff's motion for certificate of appealability. He wants an interlocutory appeal on this issue. An interlocutory appeal is, so normally you appeal at the end of a case once a judgment has been entered. But on smaller issues, sometimes you can file an interlocutory appeal and appeal that issue. It's things that it's for smaller issues. So this is one of the motions and memos that the clerk of court separated. So the motion, plaintiff Jose DeCastro, plaintiff or I, hereby respectfully moves this honorable court to issue a certificate of appealability under 28 USC 1292 sub B as to 5 particularly vexing questions on which the outcome of the court's orders depended. They're not vexing at all. In support of this motion, plaintiff submits a memorandum of law, which is fully incorporated herein. Respectfully submitted, Jose DeCastro. That's all he does is clickbait. So, plaintiff's memorandum of law in support of his motion for a certificate of appealability. Plaintiff asks the court to issue a certificate of appealability for an interlocutory appeal pursuant to 28 U.S.C. 1292b. By certifying this appeal under 1292b, this court will provide the First Circuit with occasion to pronounce more broadly on these unresolved but important questions. We're going to get to discussing that a little bit more in a little bit. I'd like, for all oral arguments, for Josh and Kate to move for in-person oral arguments. Make him travel for them. But the first issue, nunc-pro-tunc filings take effect retroactively. That's true, they do, if they're approved. They weren't approved. The court's orders have construed Intergen NV versus Greina, First Circuit, 2003, to mean that all motions filed prior to an amended complaint are rendered moot by the amendment, including nunc-pro-tunc motions to correct the record, nunc-pro-tunc notices for voluntary dismissal, and motions to nunc-pro-tunc correct the record of a voluntary dismissal. The legal description of nunc-pro-tunc motions can reasonably be read that notices of dismissal entered nunc-pro-tunc to be effective at a date prior to the amended complaint should instead make the amended complaint moot and not the other way around. And the case cited by the court doesn't say otherwise. Once again, the issue is moot because you filed an amended complaint. The issue is moot. It's not the motion is moot. The issue is moot. You filed an amended complaint. That said, you know what? I want to continue my lawsuit. So it didn't matter whether there was an error filing your notice to dismiss or not. It's moot because you filed an amended complaint. The issue. Besides, what he seems to think, well, I filed a nunc-pro-tunc motion, therefore my notice to dismiss was filed. No, that's only if the court grants your nunc-pro-tunc motion. The court denied the nunc-pro-tunc motion. Therefore, it doesn't go back in time. It's as simple as that. Second issue, local ECF rules don't define when a document is filed. They do, though. They do. If the court requires you to file in a certain way, that is controlling. Appeals courts grant a lot of deference to trial courts on how they run their courts. And filing is one of those. Formatting is one of those. For those of you following the Depp v. Heard case, go watch Law and Lumber or Emily Baker or Legal Bites, DUI Guy, the amicus briefs filed on behalf of Amber Heard. The appeals court, it's appeals court, but the Supreme Court's not going to overrule them for this. The appeals court requires all briefing to be done in 14-point font and to fit within a page limit. One of the amicus briefs was filed in 12-point font. Therefore, it breaks the rule on formatting. But it also, converting to 12-point or 14-point font, would break the rule for page limits. The court gets to set those. They have to be reasonable. The court requiring you to file by ECF is reasonable. You have access. You filed all but one motion by ECF. It's reasonable. The court's orders have construed its local rules regarding ECF filing as superseding the First Circuit's definition of filing. It hasn't. What? And what is the First Circuit's definition of filing? You haven't provided that here. How is it different? Does it say a local court can't set it? And so I said this earlier. So the supplemental complaint being treated as an amended complaint, and therefore Kate and Josh are out. I mean, they are still in the caption at the very least. So until the judge says they're out, I'm treating them as they're in, which I'm sure Kate and Josh are as well. And because Delete Lawz is pro se and dumb, I'm going to guess that the court gives him at least one chance to fix it. So that is true. It is an insult to morons. So I apologize to all morons out there. I'll do better. So Federal Rule of Civil Procedure 41A, which says the plaintiff may dismiss an action without a court order by filing a notice of dismissal before the opposing party either serves an answer, but you didn't file. It says by filing a notice of dismissal. You didn't file a notice of dismissal. End of argument. Which does not specify where the filing must be made or the manner in which it is to be filed. But the court at the beginning of this case said, here's access to the ECF system. You need to file on ECF. That's all it takes. That's all it takes. The Second Circuit, this is First Circuit though, Second Circuit is only persuasive. And potentially not even persuasive because there might be a circuit split on this issue, or the First Circuit might not have ruled on it. But the Second Circuit appellate court has held that ECF is not, strictly speaking, a local rule which has the force of law. But a local rule has the force of law in that court, and if the local rule says the ECF is the correct way to file, then it does have the force of law. This would mean the ECF can't force itself on a local court. A local court can enforce the use of the ECF. There's a difference. That's the Phoenix Ventures versus Phoenix Hotel Associates, Second Circuit. In a very similar case where a motion would have been timely, but for problems with the district court's ECF system. Okay, so this is the case where dude files. ECF kicks it out because his exhibits were too big. He fixes it. He files again. The ECF accepted it. He got the email saying, hey, you successfully filed, which Delete Lawz didn't get. He didn't get that email. It said, hey, you successfully filed. Good job. Because it does that immediately.
He went to bed. The next morning, after the deadline had passed, he woke up to find an email that said, "Hey, we rejected this filing for some arbitrary reason. Therefore, it's not filed, even though we told you it was successfully filed." So he was able to take these emails to the court and say, "Hey, look, I had to file 3 times. The third was after the deadline, but I filed." And they said, "Yeah, you filed. Therefore, we're accepting it." That's completely different. The statutes, case law, and relevant definitions of the ECF system could reasonably be read that when a party declares under penalty of perjury that it has timely filed a document in the ECF system and provides further evidence, you haven't provided further evidence, at least not good evidence. And the court has the best evidence in its possession that this has occurred. He keeps saying the court has evidence. The court doesn't have evidence. The court doesn't provide evidence. The court doesn't provide evidence. And once again, the court does not have to believe you. The court can say, "I think you're full of it. Therefore, I'm denying." That's all it takes. The court can't, in the interest of justice, rely on its own requirement that the electronic filing system move that file to the electronic docket and refuse to look at the evidence provided or the evidence in its possession that the party has requested to be discoverable and available at an evidentiary hearing that the document was filed, except for an error with the ECF. But you haven't provided any evidence of that. You haven't provided evidence of who would have that. You conclusorily state that the court has that evidence. The court does not have that evidence. Third issue, trials of fact. The court's orders have construed that it can dismiss evidence presented, including declarations under the penalty of perjury, as not having any weight, absent contrary evidence, and can assume that the best evidence in the court's possession, it's not, is irrelevant or prejudicial against the party without reviewing the evidence, denying requests for the evidence in possession of the court to be made discoverable, and denying requests for evidentiary hearings. The court has not said it has any evidence. The court does not have any evidence. You keep saying it has evidence. That doesn't grant it evidence. The court, it can say the evidence you have shown us is unconvincing. It's irrelevant. It reviewed your evidence. It was underwhelming. It was underwhelming. In Pipefitters, unpublished, once again, District Court, Northern District of Illinois, the Seventh Circuit didn't. It was in the Seventh Circuit, but this isn't a Seventh Circuit case. This is Northern District of Illinois in an unpublished opinion. The Seventh Circuit held nothing. They held nothing. Held an evidentiary hearing to find evidence proving whether a filing had been attempted. That doesn't mean it has to happen in every case. The judge is not expected to be, and this party believes that the judge is not, an expert that can make determinations of problems with an ECF system. But the court likely does have those experts available on staff or a phone call away, should make those experts available when a party requests them and to hold a proper evidentiary hearing. The court does not provide witnesses.
The court does not have those witnesses. It is your job. If you want that evidence, you go and get that evidence. You go to the custodian of those records, which is not in the local courthouse. It's not in the Massachusetts federal court. It's going to be some web developer, probably in DC. But you have to find them. The court doesn't make the phone call and say, oh, hey, by the way, this guy thinks you guys screwed up, so can you maybe, help out? You go and get it. When the court assumed that evidence didn't exist and declaring that it would take no action sua sponte, it wasn't sua sponte. You asked the court. It's not sua sponte. You asked. Sua sponte is of the court's own volition. You asked. And the court didn't assume that evidence didn't exist. You submitted no evidence. What evidence you submitted, the court said, I don't believe it. It's unconvincing. It's your job to convince the court, not the court's job to go out and find evidence to support what you're claiming. So when the court assumed that evidence didn't exist and declaring that it would take no action sua sponte, and the evidence was later provided in a motion, no. You do it first time. You bring the evidence first time. You don't get 2 bites at the apple. Besides which, the evidence is unconvincing. The court can find your evidence unconvincing. The court does not have to believe you. The court decided to look past the evidence. It didn't look past it. It looked at the evidence and said, this is unconvincing. Declared that it didn't exist. It said it's unconvincing. Instead, looked at the metadata of that evidence to try to find reasons to prove its own preconceived and prejudicial ideas. It didn't believe you. It didn't believe you. The court didn't believe you. You didn't provide convincing evidence. Found other reasons not to take action in the interest of justice, interpreting typed language severely beyond its literal meaning. Seriously. And accepted anonymous hearsay evidence that you provided. Accepted anonymous hearsay evidence of its own in higher regard than a declaration signed under penalty of perjury. You provided it. The court didn't provide that evidence. You provided it. It was a court employee, but you provided it. And evidence admitted by the moving party. But that's the thing. The court looked at your evidence and said, I don't believe it. It's unconvincing. There's not enough here. The common law, statutes, and case law could reasonably read that the court should accept plaintiff's declaration under the penalty of perjury as true. No! No, the court does not have to believe you. If you have no credibility, the court won't believe you. If you provide less evidence than the court thinks you should provide, the court's not going to make a decision in your favor. But he seems to think that because some motions require it. So let's take a look here.
Federal Rules of Civil Procedure, Rule 12. Water while it loads. Okay. 12B. No, I wanted 8, Rule 8. So, with certain pleadings, the court accepts your facts as true for the fact. And so, Rule 8, pleading standards. Claim for relief. A pleading that states a claim for relief must contain a short and plain statement of the grounds for the court's jurisdiction, a short and plain statement of the claim showing that the pleader is entitled to relief, and demand for the relief sought. So, then you go to the case law. And because after you file a complaint under Rule 8, the defense is usually going to file a Rule 12b6, motion to dismiss for failure to state a claim. So the standards set out in the Gibson versus Connolly, and then refined in Twombly, and then Iqbal versus Ashcroft, say in ruling on a 12b6 motion to dismiss, we accept the allegations as true. Is there enough in those allegations to support a claim? Delete Lawz seems to think that extends to all motions, that the judge has to accept them as true, that the judge has to accept his sworn statements as true. That's not the case. The judge can say, I don't believe you. But he seems to think the common law, statutes, and case law could reasonably read that the court should accept plaintiff's declaration under the penalty of perjury as true. No, nowhere does it say that. You don't even say where it says that. You say the common law, statutes, and case law. Provide it. Cite to it. You can't, so you haven't. Evaluate defendant's evidence to determine if it defeated plaintiff's evidence, especially given the additional evidence provided by plaintiff. If your evidence is unconvincing, the court doesn't have to accept it, period. In stating that the evidence does not exist to make the correction, to determine to the record if there was evidence, the court is saying that its discretionary decision would be to allow correction with any. No, it says if you had provided sufficient evidence and law, I would have changed. I would have found for you. But I don't believe you. And you didn't provide sufficient evidence. Therefore, I'm ruling against you. That's the standard. That's the established standard. He thinks this is a particularly vexing issue. This is easy. This is easy stuff.
Fourth issue. A court has a duty to disclose its ECF evidence, and ECF isn't perfect. The court isn't the custodian of the ECF system. It doesn't have evidence. Courts do not provide evidence. It's your job to bring your evidence. And ECF isn't perfect. But the cases you cited, where a guy got a second bite at the apple because ECF screwed up. He had an email. He had emails saying, hey, congratulations, you successfully filed. He admits he doesn't have that. He just didn't realize, even though he had already filed in ECF and received the same emails, he thought, oh, well, I didn't get one this time. That's okay. The court's orders have construed that when it has the best evidence to determine whether a party filed or would have filed, except for an error, that ECF is perfect. The court hasn't said that. It said you haven't brought sufficient evidence. The evidence in the ECF system against the perfect state of the ECF is not disclosable. What? And that the judge presiding over the case is an expert. The court hasn't said that. The court hasn't said that. Where did the court say that the judge is an expert on the ECF? But the judge can only rule on evidence. You haven't provided evidence. And he's so aggravating. And that the judge presiding over the case is an expert, and requests for evidentiary hearings with experts should be denied. So find that you haven't provided you have not provided an expert. It's your job to find an expert, not the courts. You provide an expert. You say, this is a sworn declaration from this expert on the ECF system who works with the ECF system, who is a custodian of record with the ECF system, who is a webmaster for the ECF system. This is his sworn statement. I would like to put him on the stand to find out what went wrong. Hey, the court might say, yeah, let's hear from him. But you saying, I want to hear from the court why this didn't work. What? Why would the court grant that? Why would the court grant you a hearing? It's nonsense. In Phoenix, errors occurred. But you can't show errors occurred here. In Phoenix, there was evidence of those errors. And in pipe fitters, the court accepted that ECF wasn't perfect and held an evidentiary hearing with the experts. The standard rules for review of trials of fact and evidence, case law, could be reasonably read to show that the ECF system is not perfect and that an evidentiary hearing must be held when necessary to find if errors occurred. You haven't shown that there was an error. Or if there was an error, that it wasn't your error. You have shown absolutely no evidence that it's a system error. What it means is he's a moron. Sorry, that's unfair to morons. So, the fifth and final issue. Pro se documents should be read liberally in favor of the pro se party, not liberally against. We've discussed this. pro se pleadings are read liberally. That they're, if a court can get some semblance of emotion out of your gibberish, the court's going to say, this is the motion you filed. It doesn't have to weigh your evidence more liberally. It doesn't have to give greater weight to your evidence. It can find you every bit as full of shit as a represented party. I think in my very first video discussing Delete Lawz, I used the example. If I'm unrepresented and not an attorney, and Delete Lawz sues me in Texas for something, and I file a motion to the court. Well, I file something with the court. I don't even title it a motion. I write a letter to the court. And I say, yo, judge, you've got to toss this out because I live in Utah. Therefore, you in Texas are not the boss of me. Peace out. The judge will say, that sounds an awful lot like an inartfully worded motion to dismiss for lack of jurisdiction. That is how things are construed in the pro se's favor. But let's say he filed that same lawsuit here in Utah. And I said, yo, judge, F you, you're not the boss of me. That's me saying, hey, you've got no jurisdiction over me. But the judge will say, this court is in Utah. You are in Utah. I have jurisdiction. Motion to dismiss denied. But once again, you still have to follow the rules of civil procedure. You don't get a pass on those. And the local rules for filing, for formatting, you don't get a pass. But the court's orders have construed the United States Supreme Court rulings that pro se motion and pleadings should be liberally construed in the most liberally prejudicial way to the pro se party. No, the Supreme Court does say you've got to go a little easy on the pleading standards for pro se parties. Where does it say the most liberally prejudicial way? I want a direct quote on that. The rulings could reasonably be read that the pro se documents should be construed in the way most reasonably intended by the pro se party. But you've still got to ask for something the court can give you, which would typically be in the pro se party's interests or minimally in a literal way. But here's the thing. She has thought, yeah, he's asking for things in his own interest. I'm not inclined to grant those because it's not something I can do. Or he hasn't provided any evidence that would allow me to do it. You still have to plead something. Conclusion. For the aforementioned arguments,
which clarify the controlling questions of law. Except it's well-settled law, all of it, where substantial difference of opinion exists by you. And since this order will materially advance the ultimate termination of the litigation, there could be no example better than a question on a voluntary dismissal as far as termination of litigation. All prongs of the interlocutory appeal test are met, and plaintiff prays that this honorable court certifies these issues for an interlocutory appeal. You bring your citations in the argument, not in the conclusion. Carabello Cita versus Municipality of Hormigueros, First Circuit, quoting 28 USC 1292b. Since these are pure questions of law, the Court of Appeals can decide quickly and cleanly without having to study the record. United Airlines. United Airlines. It's his whole case citation. United Airlines versus who? And Orange Chiropractic LLC versus Crayon. Here's the thing. He says these are questions of law. No. These are questions of fact. He doesn't like the way Judge Burroughs applied the facts to the law. But they're still questions of fact. Welcome, Hank's Corner. So it's just utter nonsense. Let's see. So that was filed December 7th. Also on December 7th, Judge Allison D. Burroughs' electronic order entered. Plaintiff's motion, ECF number 82, is denied. The court is not of the opinion that any order entered in this case involves a controlling question of law as to which there is substantial ground for difference of opinion, and that an immediate appeal from the order may materially advance the termination of the litigation, and therefore declines to issue a certificate of appealability. That was fast. So, moving on. Plaintiffs motion to dismiss Joshua Abrams' counterclaim. So his answer to their counterclaims was due. He filed motions to dismiss, 12B motions, which is what I'm about to read. So 12B motions to dismiss, are an alternative to an answer. And if the judge grants the motion to dismiss, the counterclaims are gone. And although they could potentially file those same claims in a different case, but that would probably have to be in Los Angeles. But assuming, though, the judge denies his
motions to dismiss, his 12B motions. He then has 14 days, unless a different time period is set by the judge, after the denial of the 12B motions to file an answer. So as of now, an answer is not due until such an occurrence, if that makes sense. But plaintiff's motion to dismiss Joshua Abrams' counterclaim. And bear in mind, he filed the exact same motions to dismiss against Kate a day or two later. So I'm just going to cover Josh's, because why be repetitive? I'm not chilly. Pursuant to Federal Rule of Civil Procedure 12B, plaintiff Jose DeCastro hereby moves this court for an order dismissing the counterclaim filed by defendant Joshua Abrams for lack of subject matter jurisdiction, lack of personal jurisdiction, insufficient process, and for failure to state a claim. In support of this motion, plaintiff submits a memorandum of law, which is fully incorporated herein. And I grabbed this, luckily, before the clerk separated it, so I have it all as one document. So, plaintiff's memorandum of law in support of his motion to dismiss Joshua Abrams' counterclaim. Plaintiff submits this memorandum of law in support of its motion to dismiss the counterclaim filed by defendant Joshua Abrams. A, lack of subject matter jurisdiction, which is 12B1. Counterclaim is not compulsory, is permissive, as it does not arise out of the transactions or occurrence that is the subject matter of plaintiff's complaint. Federal Rule of Civil Procedure 13A. This is hilarious. This is actually hilarious. This is the funniest thing I've seen today. You guys don't see it yet. But this next citation is hilarious. Counterclaim is not part of the same case or controversy, and therefore requires an independent basis for jurisdiction, citing Global and NAPS Inc. versus Verizon New England. First Circuit, 2010. Now, remember, in the very, 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 very first document we discussed today, which I discussed out of order because it was filed after this, but it was, I thought, reasonably related to discussing him threatening Judge Burroughs. The first line of that was his supplemental authority to his motion to dismiss concerning Josh Abrams. And he cited a First Circuit 1982 case, or a First Circuit case from 1982. And remember how I said there was a 2010 case that out of the First Circuit that overturned that 1982 case, making it bad case law. This is that 2010 case. He cited the correct law in his motion to dismiss. But that case law from 2010 actually says there is no need for an independent basis in all cases. for supplemental jurisdiction. So he said, oops, and filed his supplemental points of authority, citing that 1982 case that is bad law. That was overturned by this case. And here's the thing. This counterclaim was made. They're both concerning the same case or controversy. So they require, I don't think this, when it was filed, I don't think this was even a discretionary counterclaim. I think it was compulsory, because they're all about their competing YouTube videos back and forth. It is all related. But even now, it's copyright, it's still about YouTube videos made by both parties. So there is overlapping evidence. He most certainly does not know how to shepherdize. And once again, so Shepherds was a book that back in the olden days, you'd look and it would tell you, this case has been overturned. This case has negative treatment, but not all of it is bad law. So, and Shepherds was bought by LexisNexis, so it's incorporated in the LexisNexis system, and it gives you a red flag if a case has been overturned, a yellow flag if some issues in a case maybe might not be good law, but not all of the case is bad law, and a green flag if it's good law. Westlaw does the same thing, but it's not called shepardizing. My, included with my bar dues legal search software, does something different. Well, it does the same thing, but it's called something different. But so, needless to say, he's wrong here. Unless here's the thing. We're assuming that Kate and Josh are still defendants. The court has not yet said they are not, so we are assuming that they are still defendants in this case. So there is subject matter jurisdiction. So, but he says, even if counterclaim was found to be supplemental jurisdiction, its state claims would substantially dominate over the original federal claims and would raise the expense of seeking resolution and should not be allowed. So here's the thing. So if I am suing Delete Lawz and it's a state law claim and I can't get federal jurisdiction over those state law claims, there's no diversity jurisdiction. But I have one issue that is a federal question, but it's a little teeny minor issue. But there are 50 state law claims. I probably can't, with that little teeny tiny sub issue, yank all of those state law claims into federal court, since 99% of the litigation is going to be state law claims, which there wouldn't be jurisdiction. But let's say I don't have jurisdiction over state law claims, but I have 90% of my case, or even half of my case, is federal question claims. So I can sue Delete Lawz in federal court on those. But there are Also, related state law claims. I can yank those in on supplemental jurisdiction. So, and I don't actually know if Shepard's is available in book form or not. Go look in the law library. Go to your local law school. So that's what supplemental jurisdiction is. Well, this was brought in under diversity jurisdiction in the first place. Because in Delete Lawz' original complaint, it was all state law claims under diversity jurisdiction. But he's changed it to federal question, copyright. But besides what, like I said, these are all about their YouTube videos. So yeah, you have to bring in other witnesses for whether it's a copyright violation as to whether they're defamation, but it is still legal issues or still issues with YouTube videos. So counterclaim contains only state law claims, just like your original complaint. Does not establish a state that has jurisdiction over plaintiff. You, by filing in Massachusetts, gave Massachusetts jurisdiction to hear counterclaims against you. It's as simple as that. Plaintiff demands to be sued under California state law and not federal law. Defamation isn't federal law. Besides which, you defamed them in Massachusetts. I mean, if you think the choice of law is wrong, make a choice of law argument, but you've got to bring choice of law case law. You've got to bring choice of law case law. Funny enough, your original complaint against them, even though it was in Massachusetts court, probably would have been using substantive California law to decide because they allegedly defamed a California resident. You, on the other hand, allegedly defamed Massachusetts residents. So Massachusetts case law is the appropriate choice of law, most likely. But he says, as to maintain substantive rights under that state. Counterclaim fails to establish diversity jurisdiction. The factual allegations and prayer for relief do not meet the statutory minimum for a diversity case, which is $75,000. I also challenge the amounts claimed and demand that the damages be quantified and submitted with proof. That doesn't happen at this stage, champ. I mean, did Josh suffer $75,000 in damages? Probably not, but he's alleging. That's what counts at this stage. You alleged like $2 million in damages. Where's your proof of that? Well, why is it good for the goose but not good for the gander? But he also moves to dismiss for lack of personal jurisdiction. 12b-2. At the time service of process occurred for this counterclaim, I was not a resident of Massachusetts, nor physically present in the state, nor have I availed myself of the protections of California. I don't think that means what he thinks it means. Additionally, Abrams has not offered any alleged facts to establish personal jurisdiction by this court and bears the burden to do so. Here's the thing. Once again, you You, by suing in Massachusetts, gave the court personal jurisdiction to hear counterclaims. I mean, and yet you think you can sue them in California. What have they done? They haven't sued you in California, so they haven't given personal jurisdiction to California courts. But you say, nor have I availed myself of the protections of California. It's the other way around. It's, nor have I availed myself of the protections of Massachusetts. The way I'm reading this, he seems to think, nor have I availed myself of the protections of California would mean, nor have I given up the protections of the state of California. No, it's, nor have I sought the protections of the state of Massachusetts. But you have by suing in Massachusetts. It's the other way around. He's also moving for dismissal on insufficient process. 12b-4. As with the complaint, a counterclaim must contain a short and plain statement of the grounds for the court's jurisdiction, unless the court already has jurisdiction and the claim needs no new jurisdictional support. Federal Rule of Civil Procedure 8A1, which we've already looked at multiple times in multiple videos. In a permissive counterclaim, a court does not already have jurisdiction, and the counterclaim contains no statement once conclusory statements are filtered out. Local Rule 40.1G5 requires that a notice of related cases be filed. The counterclaim is missing such notice. Related cases would be if Josh has other cases against you. If he's already sued you in a different court for this. There are no related cases. So he doesn't need to make such a notice. And in the counterclaim, let's take a look at the counterclaim. Let's see, that was November 7th, wasn't it? So my internet can only do one thing at a time, apparently. Bear in mind, most of his complaints have not satisfied Rule 8 pleading standards. Counterclaim. Defendant resides in Massachusetts. Plaintiff, defendant in counterclaim, Jose DeCastro, resides in Santa Monica, California. This court has jurisdiction pursuant to 28 USC 1332, diversity of citizenship. The amount exceeds $75,000. And the court also has supplemental jurisdiction under 1367. He made the jurisdictional statement first thing in the counterclaim. I mean, unless Delete Lawz is incapable of reading, it's there. So, insufficient process, yeah, that's not going to hold up. Failure to state a claim, 12b6. Counterclaim makes no claim other than defamation. There is no federal defamation cause of action. Those are true statements. That's why it's diversity jurisdiction. Diversity jurisdiction exists for federal courts to hear questions of state law. If defamation is under a state, no state authority is listed that would allow one to plead the necessary elements, and so the pleading fails to do so. I don't know what he's trying to say there. So I'm guessing he's trying to say the complaint doesn't lay out the elements for defamation. But it does. Count 1. Abrams reasserts the facts. DeCastro has published several false and defamatory statements about Abrams. These statements were false. That's an element for defamation. And DeCastro knew of its falsity or had a reckless disregard for its truth or falsity. So he was on notice that it was false, or should have known it was false. He made these statements with actual malice. That's an element, assuming Josh is a public figure or a limited public figure. You need actual malice. That's an element. Abrams suffered financial harm. That's an element, including lost revenues, as well as emotional distress and anguish as a result of these defamatory statements. That's sufficiently pled. In addition to the facts laid out above. You don't have to lay out everything in the whole case, but that's enough to get it over the 12b6 hump. Under Federal Rule of Civil Procedure 8A2, a pleading must contain a short and plain statement of the claim showing that the pleader is entitled to relief. That is true. I think there's enough there. Counterclaim has a prayer for relief section, but cites no authority that entitles any relief, so fails to state a claim upon which relief can be granted. It lays out, so defamation is a common law tort. They laid out the elements of defamation. That's enough. I mean, did Delete Lawz in his original complaint, when he was seeking relief for their alleged defamation against him, did he say this is where the law for defamation resides? No. Conclusion. For the foregoing reasons, plaintiff requests that this court enter an order dismissing all the claims in the counterclaim pursuant to Civil Procedures 12B in their entirety. Blah, blah, blah. So, as of now, this should be denied. Unless the judge dismisses Kate and Josh as defendants in the lawsuit, this is denied. If they are no longer defendants in the lawsuit, there probably isn't supplemental jurisdiction that there's no personal jurisdiction against Delete Lawz to keep him in Massachusetts. So it probably gets dismissed, but only once Kate and Josh are no longer defendants. So finally, I think this is it's a statutory amount. It's $170,000 a year ish, 180, 90. It's been a while since I looked. And federal bankruptcy judges because they're all federal, are a little less because they're Article 1 judges of set tenure instead of Article 3 judges of a lifetime tenure. And, I think a chief judge makes more than a standard district court judge, and a senior judge is a little less. Most judges take a big pay cut unless they go from prosecution or public defender to judge. But if they go from private practice to judge, they take a big pay cut. But it's the prestige of the job sort of compensates. But yeah, so I think this is the last filing in 2 parts for this lawsuit for tonight. Plaintiff's memorandum of law in support of his motion to dismiss Joshua Abrams' counterclaim. Wait. I already did that one. That was attached. So this is the last one. Plaintiff's motion for leave to file reply and under seal, or alternatively to strike. This is a situation where you should be careful what you ask for. You should be very careful what you ask for, because you just might get it. Plaintiff Jose DeCastro hereby moves this court. It's no longer an honorable court. It's just this court. And his basis for the seal is, he doesn't want to be made fun of. That's all I can see. But moves this court to allow him to file a reply to defendant Catherine Peters' opposition, ECF number 71, to my motion for contempt, ECF number 61, and to file that reply under seal. Alternatively, to strike the portions of Peters' opposition that were not restricted to rebutting my motion for contempt. So basically, he wants to respond to her counter motion for contempt. The parties have not yet agreed on a briefing schedule which would disallow a reply, and Peter alleges new facts and introduces new arguments irrelevant to my motion. That's because it's her motion. Her reply was meant to harass and delay this proceeding. Irony is dead. Irony is officially dead. I would like an opportunity to reply to the alleged new facts and argument on the record. I am asking to file under seal because publicly speaking of harassment from defendant Peter's troll farm seems to excite the trolls to initiating more harassment. You still haven't shown harassment. And this reply is not substantially necessary to the public's right of judicial records relating to this proceeding. Declaration: I declare under penalty of perjury that the foregoing is true and correct. So, why is this stupid? Kate, in her opposition to his motion for contempt, filed a response and also said, no, you, saying, we're not in contempt, but Delete Lawz is in contempt. And the judge said, neither of you are in contempt, before Delete Lawz responded. See, she's not prejudiced. She denies motions from both parties without a response. But here's the thing. That was done. The judge said, no, he's not under contempt. But you saying, well, hang on a minute, I want to explain why I'm not in contempt. That just gives the judge another opportunity to say, you know what? I think you actually were in contempt, especially if there's an oral argument and Benjamin Wish goes in with your videos or with Kate's video and shows this was the quarter of a man live stream where, yeah, she was making fun of him, but he went into her chat and was threatening. It just gives another opportunity for that to go in front of Judge Burroughs. And this is after you've made threatening videos of Judge Burroughs, videos where you called her sugar tits. You really want to tempt fate by giving her another opportunity to rule on whether you're in contempt? This is dumb. So, Judge Burroughs, yesterday, electronic order entered. Plaintiff's motion for leave to file a reply is allowed to the extent that he may file a reply, but the court denies his request to file his forthcoming reply under seal. There is a long-standing tradition of public access to pretrial motions in our judicial system, and a party seeking to file a document under seal must demonstrate that good cause exists to do so. Citing Dunkin' Donuts franchised restaurants versus Agawam Donuts. See also Leucadia versus applied extrusion text. We hold there is a presumptive right to public access to all material filed in connection with non-discovery pretrial motions, whether these motions are case dispositive or not. To seal non-discovery pretrial motions, including related papers, such as the reply at issue here, the party seeking to overcome the presumption of public access must demonstrate significant countervailing interests, like the existence of trade secrets in the documents or confidential business information, and ensure that any sealing is narrowly tailored to shield as little from public view as possible, citing Skyhook Wireless Inc. versus Google. Plaintiffs present, the court needs to use an apostrophe, make that the possessive plaintiffs Plaintiff's present motion seeks to seal the entirety of his reply, as opposed to, for example, redacting select information. Further, plaintiff's sole argument is that publicly speaking of harassment from defendant Peter's troll farm seems to excite the trolls to initiate more harassment. This brief allegation, without more details, like I said, where's your evidence, is insufficient to overcome the presumption of public access. Therefore, plaintiff may file a response, but he may not do so under seal. Plaintiff, using the electronic case filing system, should now file the document for which leave to file has been granted in accordance with the ECF filing system administrative procedures. Plaintiff must include leave to file granted on date of order in the caption of the document. So, like I said, that is a serious case of be careful what you wish for. You might get it. And he needs to be very careful in tailoring his response, because he could talk himself into contempt. It's doubtful, but it was a definite no when the judge had denied it already. But you made it an issue again. You brought it back. So that's awfully dumb. So that's the end of the DeCastro versus Abrams filings for now. He has another matter, even though he said, this is my first time doing this. He has a case in Ironton. And that case has been dismissed. He has filed a motion for leave to file a response 2 days late, because the court had issued an order to show cause, meaning delete Lawz. Tell me, why should I not grant this motion to dismiss? Why should I not grant this motion for a default judgment to dismiss as unopposed? And tell me why by this date. In the case of, so he sued a whole bunch of people, and some are represented as the Ironton defendants, and some are represented as the Lawrence County defendants. So the Lawrence County defendants filed first. So the show cause response was due by November 17th. And for the Ironton defendants, it was due November 29th. The judge entered the order of dismissal on December 5th. Delete Lawz filed this on December 7th, asking for 2 more days, even though he would have needed over a week for the Ironton defendants and over 2 weeks for the Lawrence County defendants. And he's trying to say, well, it's not my fault because I didn't receive notice. I didn't receive the motion to dismiss or the orders to show cause. I was never served. Here's the thing. In this case, he is not using ECF. He's receiving service by mail. and he is serving by mail. Well, I don't know that he's serving by mail. He's using a process server to go to the courthouse, the federal court, to file with the court. I'm kind of assuming that's the Kent Freeman, sovereign citizen in Ironton, traveling to the court to file for him. But his argument is, well, I haven't received these. But here's the problem. He is the plaintiff. He filed the suit. He provided a mailing address in Santa Monica, California, that he doesn't monitor. But they've also emailed him every filing, in addition to mailing. So he selected to receive service at an unmonitored mailbox. That's not excusable error. That's his fault. And he says, well, my process server showed up on time a week late to file my response, but arrived after 5 o'clock, so the courthouse was closed. So this is excusable neglect. Well, why didn't you have them show up the day before? Why didn't you have them show up at noon? This is just more evidence. He thinks he gets to set the rules, and that the rules do not apply to him. I've got news for you, sunshine. Pink isn't well. He stayed back at the hotel. The rules apply to everyone, including you. So it's your fault. It's not excusable error. The court had, I mean, this is the second time he defaulted. The first one, the court actually said, all right, yeah, you defaulted, but we'll let you back in. But that's generally done on the understanding, you've been a very naughty boy, but don't do it again. He did it again. So I haven't seen a ruling on this yet. It shouldn't be granted. It shouldn't be granted. But with that, I'm 6.5 minutes shy of 3 hours. It's only 9:05 here, but for those of you on the East Coast, it's awfully late. So I'm going to get out of here. I will see you guys soon. Thanks for hanging out. If you haven't already, like, share, subscribe on your way out, and have a great rest of your day or night, whatever time it is for you. And take care.